full text of the _history _ of today's _slavery. Index. A time of prophecy. Canons of positive law. A history of slavery. Guardianship and custodianship. Banking. Foreclosure. The 12 presumptions of the Roman court. Caution of binding. Prophecies. Let it be known by all whom may receive this education and history in the lawful rise of slavery under a private system of governance, that at no time is harm intended in any way. This is purely for educational purposes, so that as discussions of the current days, and pertaining to matters of extreme stress and hardship on our planet, are under review by community and by corporation, that there be no mystery as to how we have arrived at the current state of affairs. May wisdom and peace be your guide. Go forth. Canon 3267. As a true person is both executor and beneficiary of their mind, body and soul, no party may rightfully claim higher authority to compel them to attend any 4 or more event against their will, providing such false presumptions are rebutted prior to the day and time listed on a summons. The instrument and its presumptions cease to have any effect. Canon 3263. The word summons was created in the 16th century from 2 Latin words summa, meaning to take up, to presume, assume, arrogate or undertake, to exact a punishment, and monia, meaning to remind, advise, warn, instruct or foretell. Canon 3264. A summons is usually issued in matters before a competent court to compel by presumption someone to attend in the presumed capacity of defendant, juror, or witness. The Supreme Court, that being a court of the Roman Empire practicing Roman law, under the authority of the Vatican, under the guise of the ownership of all land, all bodies and all souls, as per Pope Boniface VIII's papal bull, Unum Sanctum, of 1302, and in particular Romanus Pontifex of 1455, as declared on page 3 of the preface of the Supreme Court of Western Australia web page. As a superior court of record of unlimited jurisdiction. A concept of unlimited jurisdiction is based in a deprivation of rights. No entity or system may claim such a privilege, as it is always in 100% service to community and therefore answerable to the evolving needs of that community. 2. Assume any other position is to assume rulership, which is exactly what we have. A concept of unlimited jurisdiction is based in a system of guardianship, as you will see in the following notes. A time of prophecy. Let it be known, let it be said, this is a time of prophecy upon the planet. No other time in history has had this much written about it. This time being there end of the Mayan calendar, a 5,125 years cycle. This is also the end of a galactic cycle, that being 5x a Mayan cycle, the end of a 25,625 year cycle, and there much talked about polar shift, thus causing many of the climactic upheavals. This is the end of an era, the end of an age, the end of an empire. It is the end of the papal rule. Much has been written about there being only 112 popes. Indeed, the current pope is the 112th, and his office has been terminated as of June 1st 2nd, 201 1. See further notes to follow below. while Pope Boniface VIII was the first leader in history to create the concept of a trust, the first testamentary trust through a deed and will creating a deceased estate was not until Pope Nicholas V in 1455 through the papal bull Romanus Pontifex. This is only one of three papal bulls to include a line with the incipit for a perpetual remembrance. This bull had the effect of conveying the right of use of the land as real property from the express trust unum sanctam to the control of the pontiff and his successors in perpetuity. Hence, all land is claimed as crown land. This ist crown is represented by the ist sestuekvi trust created when a child is born, depriving them of all their beneficial entitlements and rights on the land at birth. As of June 12, 2011, Romanus Pontifex was officially collapsed, via Ritus Mandamus and Ritus Probatum, Public Register Number 98321033123501004. Thus, all jurisdiction over the land by the Roman Empire is hereby null and void, and papal rule has been terminated. For further information regarding the foundations of the history that give us the mess of the current day, please visit oneevil.org. Web link symbols triple-crown.htm. This is the time of the resurrection of divine law, of which Roman law is a subset of, and is answerable to. The canons of divine law may be found at the following link. 1. Heaven, United States of Spirits. We choose to offer links to education because the state of the planet is so dire that assisting any and all to wake up is of assistance to bringing about positive change. This time is also referred to as the waking of the dead. See notes on slavery. We understand the information contained in these documents, and on the above websites is, or should be, extremely confronting. It is an exploration of their historical architecture that we are working with today. In light of the current stock market crash and the increasing number of disenfranchised people on their planet who have quite simply had their life's work sucked away into the vortex of debt, there is the call for karma as, through knowledge, we morph our way into a new era of unprecedented redistribution of resources on the planet. Kings, queens, princes and princess, castles and slaves, extreme rich and mass poor, is over. The powers that be are very aware of what is going on, and the next few months will see more unraveling of a system that has had its stay and is imploding upon itself. Let it be known also that all sestuekvi trusts refer to the section on banking. For further insights into this trust, have now been collapsed, as of 15th of August 2011, via Ritus Probatum Renum and Ritus Mandamus, Public Document Number 9832103417482400014. That being the dissolution of the trust and office known as Aeterni Regis, also known as the Eternal Crown or the Crown and all derivatives thereof, and terminate all settlement certificates, birth certificates, death certificates, bonds and claims, including termination of the authority of the Bank for International Settlements, thus ending their system of debt slavery of the world, and full accounting, acknowledgement and surrender of all claims shall be provided within 42 days by the trustees and administrators, and as the divine creator, all saints, spirits and scripture be our witness, you are to remit to the facts and conditions herein, or let all heaven, earth, hell and history be your judge. Canons of positive law. You may question what code of thought and behavior are we engaging in response to the matters at hand. Let it be known, let it be said, there. Resurrection of divine law is upon the planet, as per all great past texts. Article 03, Power and Origin. 3.1 Authority of this covenant. This most sacred document represents a binding agreement between equals, entered in free will and full knowledge, being the highest, most powerful, superior contract and covenant of all past, present and future possible agreements between the parties of all spirits living and deceased, as unique spirits and mind, and the divine as the absolute, the one, there. All, the universe, all galaxies, all stars, all planets, all life, all existence, all mind. As this covenant represents the literal, legal, spiritual and lawful fulfillment of all previous divine covenants, this most sacred covenant is the logical, legitimate and rightful conclusion of any and all historic and valid divine covenants. Therefore, all claimed rights, powers, property, privileges, customs of these historic divine covenants are hereby enjoyed and then conveyed to the sole authority of the Society of One Heaven. Furthermore, as the existence of this highest, superior and unbreakable covenant is the fulfillment of all previous divine covenants and their conveyance of all rights and powers of such covenants, this most sacred covenant hereby lawfully voids any claims of the continuance of separate and historical covenants between men and women and spirits, and any claimed covenants between men and women and the divine. From the day of divine agreement and understanding until the end of the universe, no claimed laws based on one or more of these invalid historical covenants may rightly claim superior status to any law derived from this covenant. Such claims are null and void ab initio, from their beginning, of such false claims with those making such false claims subject to a great binding. Refer to 10.0. From Canons of Positive Law, Article 1, Section 8 and 9. 8. When referring to these canons of positive law collectively, it may also be taken that the primary and original form of these laws resides as a supernatural, spiritual document registered in heaven first, and a physical document registered in the great register and public record of one heaven upon the earth second. Therefore, wherever an official and valid form of these laws is present in physical form, it shall be bound to its spiritual form, from which it derives its spiritual power and authenticity. And 9. Let no man, woman, spirit or officer of a lesser society place themselves in grave dishonor of divine law, natural law and the living law upon denying their validity of these canons of law. Having been warned, any act in defiance of these laws shall have no effect, and any spiritual invocation in opposition to the validity of these laws shall be immediately returned upon the Maker. As it is written, so be it. 3.0 A History of Slavery. Article 325 Settlement. Birth Certificate. Canon 3347. A settlement certificate, also known as a birth certificate since 1837, is an official document issued to validly recorded paupers, granting them certain basic rights and entitlement to benefits in exchange for recognition of their status as being owned as property and lawful slaves, also known as indentured servants and bondsmen. A settlement therefore is equivalent to a voluntary slave plantation. Canon 3348. Under King Henry VIII of England and his Venetian, Magyar advisors, the first poor laws were promulgated around 1535, coinciding with the first official mandate requiring uniform record-keeping by all Church of England parishes of births, deaths and marriages. The poor considered the responsibility of the Church, including ensuring they had ample work and did not starve to death, as they were considered by default the property of the Church. Canon 3349. Under Queen Elizabeth I of England, a set of measures were introduced, which had the effect of accelerating the disenfranchisement of land peasants into landless paupers. Under the Erection of Cottages Act 1588, peasants required local parish permission to erect dwellings, whereas before the erection of a dwelling by a land peasant on their lord's land was considered a right. As a result, the ranks of the landless poor, or paupers, swelled. Canon 3350. Under Queen Elizabeth I of England, the laws concerning their administration and care of the poor refined through the Poor Law 1601, which introduced a basic set of rights for the poor as well as the introduction of 2 overseers of the poor, guardian, in each parish, elected at Easter and funded through the first levy tax, through local rates, now called council taxes, on property-owning ratepayers. Canon 3351. Under Charles II of England, the concept of settlements as plantations of working poor controlled by the Church of England was further refined through the Settlement Act, 1662, and Poor Relief Act, 1662, including, for the first time, the issuance of settlement certificates equivalent to a birth certificate, passport and social security rolled into one document. A child's birthplace was its place of settlement, unless its mother had a settlement certificate from some other parish stating that the unborn child was included on the certificate. However, from the age of 7 upwards, the child could have been apprenticed and gained a settlement for itself through called indentured service, or voluntary slavery. Also, the child could have obtained a settlement for itself by service by the time it was 16. Canon 3352. Under the reforms of the Settlement Act, 1662, and Poor Relief Act, 1662, no one was allowed to move from town to town without their appropriate settlement certificate. If a person entered a parish in which he or she did not have official settlement, and seemed likely to become chargeable to the new parish, then an examination would be made by the justices, or parish overseers. From this examination on oath, the justices would determine if that person had the means to sustain himself. The results of the examination were documented in an examination paper. As a result of the examination, the intruder would then either be allowed to stay, or would be removed by means of what was known as a removal order, the origin of the modern equivalent of an eviction and removal notice when a sheriff removes people from their home. Canon 3353. According to the various settlement acts from the 17th century onwards, until the introduction of birth certificates, the issue of a settlement certificate was considered a privilege, not a right. If a peasant wanted to move, the home parish could choose to issue a settlement certificate, which then effectively became an indemnity insurance to the new parish. If the pauper was unable to earn a living, a settlement certificate was only valid if it bore the seals of the overseers of both parishes and that of their local justices and was not transferable. This is the same model of modern passports for citizens listed as paupers, used today. Canon 3354. Due to the increase in the number of poor, in 1723 a new law was passed called the Workhouse Test Act, 1723, in which those who wished to claim benefits and relief as poor now had to enter a workhouse, being essentially a prison for men, women and children, to perform some set work, to ensure that all poor were accounted and could be identified. New laws were also introduced to force the paupers to wear a P on their right shoulders as a mark of their status. This is both the origin of the P, still placed as a mark on modern passports and other official documents, and the P worn by prisoners from the 20th century. Canon 3355. Beginning in 1773 with the Enclosure Act 1773, followed by the Enclosure Consolidation Act 1801, English Parliament effectively privatized massive amounts of common land for the benefit of a few, causing huge numbers of land peasants to become landless paupers and therefore in need of parish assistance. The Enclosure Acts are the foundation of land title as it is known today. Canon 3356. Because of the deliberate legal theft of land under parliamentary enclosure laws of the late 18th and early 19th century, the number of paupers dramatically increased. This led to the most awful and cruel laws being introduced to deliver to an elite few the slave labor force needed for the Industrial Revolution through the Poor Law Amendment Act 1834, which effectively stated that the poor could not receive any benefit unless they were constantly employed in a workhouse prison. Thus, despite international treaties against slavery, the very worst slavery being wage slavery or lawful slavery was born, whereby men, women and children lived in terrible conditions and were worked to death. Canon 3357. Beginning in 1834, a number of historic changes were introduced to their record-keeping of births, deaths and marriages, the issuance of documents and the management of the poor. In 1834, British Parliament introduced the Poor Law Amendment Act 1834, which reorganised Church of England parishes into unions which would then be responsible for the poor in their area and administered by a Board of Poor Law Guardians, also known as the Board of Guardians. The clerks of magistrates' courts still hold the power of a clerk of the Board of Guardians, and 2. In 1835, the Municipal Corporations Act, 1835, was introduced, which effectively standardized the corporate model for towns and boroughs, including making the municipality with elected officials responsible for data collection and service administration, and 3. In 1836, the Births and Deaths Registration Act, 1836, was introduced, which for the first time created the General Register Office. and the requirement for uniform records of births, deaths and marriages across the empire by municipal councils and unions of parishes. Thus, on the 1st of July 1837, the birth certificate was formed as the successor of their settlement certificate for all paupers disenfranchised of their land. Birthright to be considered lawful, voluntary, slaves with benefits provided by the local parish, region underwritten by the Society of Lloyds. As it is still today. Canon 3358. Beginning from 1871, further historic changes in the administration of vital statistics such as birth certificates and death certificates were there. Introduction of health districts or sanitary districts. The Local Government Act of 1871, Public Health Act 1872 and Public Health Act 1875 created a system of districts called sanitary districts governed by a sanitary authority responsible for various public health matters, including mental health, legally known as sanity. Two types of sanitary districts were created, being urban and rural, while the sanitary districts were abolished in 1894 with the Local Government Act of 1894. Their administration of the poor is still maintained in part under the concept of district health boards of guardians, including magistrates and other justices of the peace. Canon 3359. Since 1990, under the United Nations and the World Health Organization (WHO), by the Convention on the Rights of the Child, the system of issuing birth certificates as proof of a man or woman being a permanent member of the underclass has become an international system. Canon 3360. One fundamental flaw that remains within the settlement, birth certificate system for the Roman cult and its agents remains the fact that a settlement certificate is proof that a man or woman must have been born on the land for the certificate to have effect, regardless of convoluted subsequent presumptions of what the certificate actually represents. If a man or woman was not born on the land somewhere, a certificate could not be issued. Therefore, any rejection or return of a birth certificate serves as perfected evidence that a man or woman was born on the land and support to any affidavit of truth concerning their immutable rights from the divine Creator. Canon 3361. As settlement certificates and later birth certificates are solely and purposefully designed to disenfranchise men and women from their rightful inheritance through voluntary enslavement and admission to being paupers, the system of birth certificates is wholly without legitimacy, a global system of organized fraud and crime and without lawful effect. 4.0 Guardianship and Custodianship. Article 326 Guardians. Board, Council. Canon 3363. The Board of Guardians, later known as Guardian Committee and simply as the Council of a county or borough, is a formal, geographically bound body, constituted by various public statutes, granting certain legal authority and duty of care to its elected and appointed members for the physical, mental, personal and properly interests of others, now commonly called wards. In most Western nations today, the Board of Guardians is effectively the town, city, county or borough council. Canon 3364. In 1834, British Parliament introduced the Poor Law Amendment Act, 1834, which reorganized Church of England parishes into unions which were then be responsible for the poor in their area and administered by a Board of Poor Law Guardians, also known as the Board of Guardians. The board was assisted by a new office known as the Clerk of the Board of Guardians, also known as the Clerk of the Guardians, being an additional title granted to the existing local Clerk of the Peace, responsible for administering the records and matters of the magistrates' court of the area. Canon 3365. The Clerk of the Peace, assuming the powers of Clerk of the Guardians as well as Clerk of the Magistrates from 1836 onwards, was granted even greater power as the Registrar of the Court of Record and responsible for the accurate recording of births, deaths, marriages and events within their parish union. Importantly, the Clerk of the Guardians was said to be in custody of all persons on the poor rolls on account of their name being registered at birth. Canon 3366. From 1871 onwards, the Board of Guardians and Clerk of Guardians were granted even more guardian responsibilities with the creation of districts called sanitary districts governed by a sanitary authority, responsible for various public health matters including mental health, legally known as sanity through the Local Government Act of 1871, Public Health Act 1872 and Public Health Act 1875. The boards of Guardians and Clerk of Guardians were also granted guardianship over minors through the Guardianship of Infants Acts 1886 and 1925. Canon 3367. Significantly, from 1879 with the Summary Jurisdiction Act, 1879, there Clerk of the Peace, also known as the Clerk of the Guardians, also known as the Clerk of the Magistrates, also known as the Registrar of the Court of Record, was granted the powers of the Clerk of the Privy Council as their agent for summary judgment matters. Thus when the Clerk of the Magistrates or their agent such as a justice's clerk issued a summons or warrant under Crown seal, the matter could be handled as a summary judgment simply by evoking these extraordinary powers over all subjects, regardless of whether they were poor, insane or a minor. Canon 3368. In 1929 in the United Kingdom with the Local Government Act, 1929, the boards of guardians as well as the position of Clerk of Guardians were finally abolished by allocating their powers to a different office. Board of Guardians became Council of a county or borough, and 2. Clerk to the Guardians became Clerk of the County Council or town clerk, and 3. Guardian as an individual became a member of the Council of a county or borough, and 4. Poor Law Union became a county or borough. Canon 3369. In most Western countries following Roman cult law and English law, the town clerk remains effectively the Clerk of the Guardians, their Clerk of the Peace, the agent of the Clerk of the Privy Council, their Clerk of the Magistrates and Registrar of the Court of Record, with the justices clerks of magistrates' courts their agent possessing their claimed power to conclude summary judgments. Canon 3370. Based on the continued claimed powers of the clerk and their agents, a magistrates' court is effectively a court of wards and guardians with a hearing effectively either examination or a summary judgment for petty matters limited by cost and penalty. Canon 3371. Upon the presumptions of power claimed by the clerks, when one attends a Roman law magistrate's court, it is presumed one has consented to being treated as a ward unless such presumptions are rejected before attendance or immediately upon being brought forcibly before the magistrate's court. Canon 3372. As the claimed authority of councils and boards of commissioners in their capacity as boards of guardians is founded on a history of fraud and the disenfranchise of men and women from their rightful inheritance through voluntary enslavement and admission to being paupers, such powers are wholly without legitimacy and lawful effect. Canon 3373. Given the claimed authority and powers of the town clerk and their agents by claiming historic authority as effectively the clerk of the guardians, the clerk of the peace, the agent of the clerk of the privy council, the clerk of the magistrates and registrar of the court of record is based on a historic of fraud, voluntary enslavement and false premise, all authority and power of justices, clerks of magistrates, courts and their principle is null and void from the beginning. A world of slavery. You are legally a slave, just as your parents, your grandparents and great-grandparents were slaves. You may be lucky enough to live in a pleasant plantation with other slaves, managed by overseer slaves, such as police, judges, doctors and politicians, where few examples of slave cruelty occur. Or you may be witnessing changes in their community plantation, which is part of a state slave plantation and national slave plantation where there is more crime, more misery, and death. The fact that you are a slave is unquestionable. The only unknown is whether you will permit your children and their children to also grow up as slaves. Upon a new child being born, the executors or administrators of the higher estate willingly and knowingly convey the beneficial entitlements of the child as beneficiary into the first sestuek, vi. trust in the form of a registry number by registering the name, thereby also creating the corporate person and denying the child any rights as an owner of real property. You are a slave because since 1933, when a child is born, their executors or administrators of the higher estate knowingly and willingly claim the baby as chattel to the estate. The slave baby contract is then created by tricking the parents to signing the baby away through the deceitful legal meanings on the live birth record. This live birth record as a promissory note is converted into a slave bond sold to the private reserve bank of the estate and then conveyed into a second and separate sestuek, veal trust per child, owned by the bank. Upon the promissory note reaching maturity, and the bank being unable to seize the slave child, a maritime lien is lawfully issued to salvage the lost property and itself monetized as currency issued in series against the sestuek, veal trust. You are a slave because since 1540 and the creation of the first sestuek Act, deriving its power from the papal bull of Roman cult, leader Pope Paul III of the same year, whenever a child is baptized, and a baptismal certificate is issued by the state at birth or church, the parents have knowingly or unknowingly gifted, granted and conveyed the soul of the baby to a third sestuek vi trust owner by Roman cult, who has held this valuable properly in its vaults ever since. managed by the Temple Bar since 1540 and subsequent bar associations from the 19th century representing the reconstituted guild are responsible as grim reapers for reaping the souls, or salvage, also known as salvation of souls. Therefore, under the UCC slave laws which most slave plantations of the world operate, you can never own a house, even though they trick you into believing you do. You never really own a car, or boat, or any other object. You only have the benefit of use. Indeed, you do not even own your own body, which is claimed to have been lawfully gifted by your parents at your birth on the commercial transaction document we know as the live birth record, against which a QZIP number is issued and sold to the central bank. Yes, the banks claim your flesh. The banks are indeed the modern slave owners, hiding these indisputable facts upon which their money system is built from the people. You may not realize you are a slave under the slave laws of uniform commercial codes, UCC, but may still erroneously believe you are slave with more rights as used to be afforded under common law until it was largely abolished back in 1933 without properly telling you. The word common comes from 14th century Latin communis, meaning to entrust, commit to a burden, public duty, service or obligation. The word was created from the combination of two ancient pre-Vatican Latin words committo equals to entrust, commit, and munis equals burden, public duty, service or obligation. In other words, the real meaning of common is first formed because of the creation of the Roman trust over the planet is the concept of voluntary servitude or simply voluntary enslavement. Common law is nothing more than the laws of voluntary servitude and the laws of voluntary slavery to the Roman cult and their Venetian slave masters. It is the job of the overseer slaves to convince you that you are not slaves. The common law still exists and has not been largely abolished and replaced with commercial law, to confuse you, to give you false hope. In return, they are rewarded as loyal slaves with bigger homes to use and more privileges than other slaves. The reason why the overseer slaves such as judges, politicians, bankers, actors and media personalities are forced to lie and deny we are all slaves is because the slave system of voluntary servitude or common law was not the first global slave system, but merely its evolution. Before the emergence of common law, we were all subject to being considered mere animals or things under canon law of the Roman cult, also known as the law of the sea, or admiralty law. Under admiralty law, you are either a slave of the ship of state, or merely cargo for lawful salvage. Thus in 1302 through Unum Sanctum, the Roman cult unlawfully claimed through trust their ownership of all the planet and all living things as either slaves, or less than slaves with things administered through the court of Rota. This court, claimed as the supreme court of all courts on the planet, was initially abolished in the 16th century only to be returned in 1908 under Pope Pius X as a purely spiritual ecclesiastical court of 12 apostolic prothonotary spirits, implying the 12 apostles. Since then, this new purely spiritual court has remained in constant session, with the local courts using these powers to administer divine immortal spirits expressed in trust into flesh vessels as mere dead things. Yet this is not the only form of slave law still in force today. Instead, the oldest, the most evil and based on false history are the slave laws of the Menashe, also known as the Rabbi through the unholy document of hate first formed in 333 known as the Talmud of the Menashe, the false Israelites. Through the Talmud of the false Israelites, the whole planet is enslaved with the servants of the chosen people known as Canaanites or Canaanites, also known as the Scythians, and then the rest as the Goy-Ju and Goyim, namely meaning the cattle, the dead lifeless corpses. Ultimately, you are a slave because you remain profoundly influenced by your education and community at large, and because many choose to continue to think and act like a slave, waiting for someone to help them, tell them what to do, and be happy accepting breadcrumbs of benefits when the system has reaped millions of dollars of your energy. A prison designed with no way out. Before this time, the system of global slavery and the treatment of the world as one large slave plantation was designed so there is no way out, as evidenced through the courts of the priests of Baal, known as the judges of most legal systems in the world. Even the most educated of men and women may remain tricked into believing that upon self-representation they may claim their common law rights as a means of defense, only to find the judge lawfully rejects any and all claims. As the first law of the courts is the Uniform Commercial Codes of Slavery is introduced in 1933, the defendant is an employee of a corporation and therefore automatically assumes the liability of any injury. Unless they can pay, they may be sent to prison. If such a trickster as the judge is challenged, they are permitted to escape to their chambers and call upon even greater power to return and magically establish a new court, without telling the defendant. They have now entered Admiralty Court, or the laws of the sea in accordance with Canon law of the Roman cult issued in 1983. Now, the judge can impose grave penalties upon such an unresponsive defendant, including contempt of court and other punitive prison sentences, with the defendant having no rights unless they know canon law concerning juridic persons and establishing standing above being called a thing. Sadly, few people actually know the original meaning of thing as a judicial meeting, or assembly, a matter brought before a court of law, a legal process, a charge brought, or a suit or cause pleaded before a court. This meaning is then used with devastating effect through the heretical concept of Pius X from 1908 to claim the dead apostles sit in permanent and open session as the 12 prothonotary of the sacred rota, as the highest supreme court on the planet. So when a man or woman receives a blue or yellow notice from the court issued through this unholy knowledge of canon law, by the time they come to court, they are automatically a thing. When a man or woman seeks to defend themselves by seeking to speak before the judge, they automatically consent to being a thing. Thus a judge with knowledge of such trickery can silence any man or woman by lawfully threatening contempt of court if their thing does not stop making noise. Indeed, it is the Roman cult canon law of 1983 that establishes all courts are oratories, with judges holding ecclesiastical powers as ordinaries and their chambers as chapels. Thus the bar associations around the world have assisted judges in learning of their new powers in order to counteract those men and women who continue to wake up to their status as slaves, but demonstrating how to remain in honor with such perverse law and ensure such terrorists are sent to prison for long sentences as a warning to others. If a judge so inclined to ensure an educated defendant is lawfully sent to prison or worse, he or she may run away for a third and final time to their chamber and invoke their most powerful standing as rabbi of a Talmud court under the Talmudic laws of the false Israelites of the house of the 12 tribes of Manasseh. Now, even a judge in a nation that is against the death penalty may choose to impose a lawful sentence against any goy, Jew or goyim who dares injure an Israelite, which is normally death. However, while judges in the United States and other nations have started to be trained in the reimposition of Talmudic law, it is at the hands of the false Manasseh, also known as the elite anti-Semitic parasites, also known as the Black Khazars and Venetian noble families. Ultimately, it is enough for judges, clerks and members of the bar to know that they hold our property in their Sestuekvi trusts and that we are completely without effective rights, until we challenge their fraud. Yet, even when you challenge their fraud, many deny and outright lie on the records to deny they hold trustee and executor powers, with the case being a constructive trust and executor of the Sestuekvi trust, from which powers are being drawn for the form of the court. Banking. Article 100 Sestuekvi Trust. Canon 2042. In 1534, prior to the first Sestuekvi Act, 1540, Henry VIII declared the first Sestuekvi type estate with the Act of Supremacy which created the Crown Estate. In 1604, 70 years later, James I of England modified the estate as the Crown Union, Union of Crowns. By the 18th century, the Crown was viewed as a company. However, by the start of the LQTH century, around 1814 onwards, upon the bankruptcy of the company, 1814-151, it became the fully private Crown Corporation, controlled by European private banker families. Canon 2043. Since 1581, there has been a second series of Sestuekvi estates concerning the property of persons and rights which migrated to the United States for administration, including in 1651 the Act for the Settlement of Ireland 1651-52, which introduced the concept of settlements, enemies of the state and restrictions of movement in states of emergency, and 2. In 1861 the Emergency Powers Act 1861, and 3. In 1931 the Emergency Relief and Construction Act 1931-32, and 4. In 2001 the Patriot Act 2001. Canon 2044. Since 1591, there has been a third series of Sestuekvi estates concerning the property of soul and ecclesiastical rights which migrated to the United States for administration, including in 1661 the Act of Settlement 1661-62, and 2. In 87 the District of Columbia Act 1871, and 3. In 1941 the Lend-Lease Act 1941. Canon 2045. By 1815 and the bankruptcy of the Crown and Bank of England by the Rothschilds, for the first time, the O.G.W trusts of the United Kingdom became assets placed in private banks, effectively becoming private trusts or fideikommissary trusts administered by commissioners, guardians. From 1835 and the Wills Act, these private trusts have been also considered secret trusts whose existence does not need to be divulged. Canon 2046. From 1917-18, with the enactment of the Sedition Act and the Trading with the Enemy Act in the United States and through the United Kingdom, the citizens of the Commonwealth and the United States became effectively enemies of the state and aliens, which in turn converted the fideikommissary private secret trusts to foreign situs, private international trusts. Canon 2047. In 1931, the Roman cult, also known as the Vatican, created the Bank for International Settlements for the control of claimed property of associated private central banks around the world. Upon the deliberate bankruptcy of most countries, private central banks were installed as administrators, and the global O.G.W foreign situs trust system was implemented from 1933 onwards. Canon 2048. Since 1933, when a child is born in a state under inferior Roman law, 3 O.G.W trusts are created upon certain presumptions, specifically designed to deny the child forever any rights of real property, any rights as a free person, and any rights to be known as man and woman rather than a creature or animal, by claiming and possessing their soul or spirit. Canon 2049. Since 1933, upon a new child being born, the executors or administrators of the higher estate willingly and knowingly convey their beneficial entitlements of the child as beneficiary into the first O.G.W trust in the form of a registry number by registering the name, thereby also creating the corporate person and denying the child any rights as an owner of real property. Canon 2050. Since 1933, when a child is born, the executors or administrators of the higher estate knowingly and willingly claim the baby as chattel to the estate. The slave-baby contract is then created by honoring the ancient tradition of either having the ink impression of the feet of the baby onto the live birth record, or a drop of its blood, as well as tricking the parents to signing the baby away through the deceitful legal meanings on the live birth record. This live birth record as a promissory note is converted into a slave bond sold to the private reserve bank of the estate and then conveyed into a second and separate O.G.W trust per child owned by the bank. Upon the promissory note reaching maturity and the bank being unable to seize the slave child, a maritime lien is lawfully issued to salvage the lost property and itself monetized as currency issued in series against the O.G.W trust. Canon 2051. Each O.G.W trust created since 1933 represents one of the three crowns representing the three claims of property of the Roman cult, being real property, personal property and ecclesiastical property, and their denial of any rights to men and women, other than those chosen as loyal members of the society and as executors and administrators. Canon 2052. The three O.G.W trusts are the specific denial of rights of real property, personal property and ecclesiastical property for most men and women, corresponds exactly to the three forms of law available to the gaoler of the Bar Association courts. The first form of law is corporate commercial law is effective because of the first C.S.T.U.E.K.V.I. trust. The second form of law is maritime and trust law is effective because of the second C.S.T.U.E.K.V.I. trust. The third form of law is Talmudic and Roman cult law is effective because of the third C.S.T.U.E.K.V.I. trust. Of baptism. Canon 2053. The birth certificate issued under Roman law represents the modern equivalent to the settlement certificates of the 17th century and signifies the holder as a pauper and effectively a Roman slave. The birth certificate has no direct relationship to the private secret trusts controlled by the private banking network, nor can it be used to force their administration of a state or nation to divulge the existence of these secret trusts. Canon 2054. As the C.S.T.U.E.K.V.I. trusts are created as private secret trusts on multiple presumptions including the ongoing bankruptcy of certain national estates, they remain the claimed private property of the Roman cult banks and therefore cannot be directly claimed or used. Canon 2055. While the private secret trusts of the private central banks cannot be directly addressed, they are still formed on certain presumptions of law, including claimed ownership of the name, the body, the mind and soul of infants, men and women. Each and every man and woman has the absolute right to rebuke and reject such false presumptions as a member of one heaven and holder of their own title. Canon 2056. Given the private secret trusts of the private central banks are created on false presumptions, when a man or woman makes clear their live-born record and claim over their own name, body, mind and soul, any such trust based on such false presumptions ceases to have any properly. Canon 2057. Any administrator or executor that refuses to immediately dissolve a C.S.T.U.E.K.V.I. trust upon a person establishing their status and competency, is guilty of fraud and fundamental breach of their fiduciary duties requiring their immediate removal and punishment. 6.0 Foreclosure. Article 108 Foreclosure. Canon 2133. A foreclosure is a formal hearing relating to a standard mortgage requested by a financial institution or interested party to deprive a tenant of their right of redemption, also known as equity of redemption, declare them delinquent and therefore terminate their tenancy without legal recourse, permitting them to be legally evicted. Canon 2134. Delinquency is not merely the failure to perform the obligations specified under a lease, but the failure to provide any form of considered attempt to perform. Therefore, a tenant that continues to perform under severe financial difficulties, even if the amount is grossly under their original obligations, cannot be considered delinquent and foreclosure is unlawful. Canon 2135. Foreclosures are equivalent to the court process of replevin, also known claim and delivery as part of repossession of other leased properly. Replevin is a formal hearing requested by the owner, lessor, against the user, lessee, relating to a form of goods their owner seeks permission to seize. Under the laws of most estates, a Replevin is required before seizure. Canon 2136. In accordance with inferior Roman trust law, estate law and law in general, a foreclosure hearing and many Replevin hearings are a deliberately fraudulent act conspired between the financial institution, interested party and the courts to deliberately conceal the nature, function and remedy available to the tenant and lessee, and encourage delinquency. Canon 2137. In the first instance of gross fraud relating to foreclosures, the borrower, also known as the mortgagor, is not made aware by the court, nor the financial institution that by a standard mortgage deed and title they are in a fixed-term lease with the institution as a landlord. This alone should be grounds for any foreclosure to be dismissed on grounds of concealment and misrepresentation. Canon 2138. In the second instance of gross fraud relating to foreclosures, the borrower is not made aware that as a tenant under a fixed-term lease, their obligation is to pay the rent to the landlord representing the interest. If a tenant were to make good part or all of the arrears in rent, then by contract law, their fixed-term lease cannot be terminated as a delinquent tenant, even if the principal of the loan remains outstanding. Furthermore, a long-term tenant normally has the right to make remedy of any arrears even after dispossession, and regain possession of the property. These remedies is what is known as the tenant's right of redemption or equity of redemption. Canon 2139. In the case of actions of replevin and repossession, the lessee is rarely made aware that they do not, nor ever will own the asset. Especially in the case of motor vehicles, and that as a lessee, their primary obligation is to pay the rent on the asset in the form of their interest. If a lessee were to negotiate the terms of their rent and still pay, then almost all actions of replevin and repossession are unlawful. Canon 2140. In the third instance of gross fraud relating to foreclosures, their borrower is not made aware that their property is held in sestitui K.V. trust, being a temporary testamentary trust, and so it is the financial institution that is responsible for all property taxes, being rent charged by the landlord being the state or county to the leaseholder being the bank. Canon 2141. In the fourth instance of gross fraud relating to foreclosures, their borrower is not made aware by the financial institution of any material alterations to the deed and title made by the institution, particularly in non-selling or reselling the mortgage and recouping their loan, as the material alteration of a deed and will of a testamentary trust is a most serious breach of fiduciary duties. This fact alone should be grounds for a foreclosure hearing to be dismissed and any contract claims by the institution rendered null and void. Canon 2142. Whenever an inferior Roman court has permitted the complete and deliberate corruption of the most basic tenets of Roman Western law by permitting foreclosure hearings to proceed, the courts and law officers through such overwhelming fraud consent and agree by their actions that all forms of Roman law, Talmudic law and other inferior law has ceased to exist and is null and void. Canon 2143. Any person guilty of participating in the gross fraud and corruption of law through the manner described by foreclosure consents and agrees they are personally liable to all future penalties and reparations, punishment and consent and agree they are without any lawful authority whatsoever. Article 136. Canon 2360. Any bank, treasury or financial institution that deliberately conceals payments under equitable title as interest or some other description instead of rent is guilty of gross fraud and immediately loses the right of legal title over any and all instruments committed through fraud. Canon 2361. When any bank, reserve bank or treasury deliberately conceals their issuing of currency and payments under equitable title as interest or some other description instead of rent consents by such fraud and concealment against the people that all liability shall be personally returned to the ultimate owners of the bank, then all leases shall be cancelled and all legal and equitable title shall be forfeited, including their right to remain as a central bank. The 12 Presumptions of the Roman Court. Article 299 Roman Court. Canon 3224. A Roman court is a forum for the exclusive private business of a law, bar, guild sanctioned by the Roman cult, also known as the Vatican, in which members of the guild presume certain roles on behalf of the government in order to make profit for the guild and its members through direct asset seizure and the commercialization of various securities, bonds and bailments. Canon 3225. The meaning and source of the word court in respect of Roman court is derived from the Latin word corsio meaning securities, bond, and bailment as the primary commercial business of ancient Roman cult-sanctioned law guilds since the 13th century. Canon 3226. Prior to the creation of the bar associations in the 19th century, their private bar guilds were known as guilds as well as livery companies and often by the name as judges and notaries since their 13th century coinciding with the invention of indulgences of their Roman cult. Canon 3227. In order to make guild money, called gilt or guilty, the private bar guilds normally oversee a unique hidden trust for each controversy or suit that comes into the private Roman court. Any bonds that are generated, called gilt bonds, are connected to the hidden trust, which the private bar guild members are sworn to deny exists. Canon 3228. A Roman court does not operate according to any true rule of law, but by presumptions of the law. Therefore, if a presumptions presented by the private bar guild are not rebutted, they become fact and are therefore said to stand true. There are 12 key presumptions asserted by the private bar guilds which if unchallenged stand true. Being public RICO,